Constitution, he can as a citizen. What Article 2, Clause 2 prohibits is any person exercising state authority except as authorized under the Constitution. The Constitution has nowhere authorized a president to initiate and use state authority in initiating a constitutional change process. We had the BBI. We've just been referred to Kenya Gazette notices signed by the President of the Republic of Kenya and Chief of the Kenya Defense Forces. He was exercising state authority, doing what the functions of his office does not permit him to do. He was violating Article 2, Clause 2. This is the one article the AG and others of the similar persuasion have shied away from. They should quote Article 2, Clause 2. Any public servant, any state officer, as an individual, can initiate any amendment to the Constitution, no problem. But just don't exercise state authority in the process of so doing. Don't use public funds in so doing. Don't use public facilities in so doing. When the president seeks re-election as president, if he's doing it properly, he doesn't use state funds. He uses his own money or his political party's money and things like that. He doesn't go to the national treasury, come on, give me this budget to mount my re-election. No. He fights for that as an individual. Likewise in this particular case. So Article 2, Clause 2 prohibits the usage of state machinery in purporting to change the Constitution. So any state officer, any public officer wants to change it, go ahead as an individual, just like the rest of us, but just don't use state resources or state machinery in so doing. I'll now turn to the issue which is generating a bit of some controversy here, presidential immunity. I'm the one, through my petition in the High Court, E426 of 2020, who brought or dragged the president to court. And I asked for the orders that I asked for, based on Article 143, Clause 2. The pronouncement that came from the High Court, as affirmed by the Court of Appeal, was not exactly what I asked for. I simply said that you can institute civil proceedings against a president for actions that he undertakes or omissions outside his functions of office. In other words, Article 143, Clause 2 protects him, gives him immunity when he's performing the functions of office as president. So I asked for clarification. You can bring a suit against the president if it touches on a matter outside the functions of presidential office. And I basically said, when he was busy setting out Kenya Gazette notices, establishing the BBI steering committee, he was acting outside the functions of office, because there is nowhere where the Constitution authorizes him to engage himself in constitutional change matters outside Article 256. Yet here he was establishing a public body to consider the change of the Constitution. Because he had acted outside the functions of his office, Article 143, Clause 2 did not prohibit us from instituting an action against him. And that is basically what I had asked for. But what the High Court came up with was that you can sue him for any conduct, his actions or omissions, that are contrary to the Constitution. The pronouncement of the court was wider than what I had asked for. I had confined myself to conduct outside his functions of office. But if you apply what the High Court said, you can sue him for anything that he does that is unconstitutional. Unconstitutional includes both functions within his office and functions outside his office. And that is a bit that I disagree with. And I'm saying that particular order was wider than my prayer. I'm urging this court to revert to my prayer and not go beyond my prayer to what the court, High Court and as affirmed by the Court of Appeal, went. I'll give an example. If I use the pronouncement of the High Court and the Court of Appeal as law, And if I am Justice Joel Ngugi or Justice George Odunga, who are involved with this matter at the High Court, because they ruled in the manner that they did, and the president doesn't like them because they scuppered reggae or they messed up BBI, his pet project, when other judges were being promoted to the Court of Appeal, they were left out. I mean, for us Kenyan citizens speculating, we say the only reason why they were left out was not because of their inability to act as judges, but it was simply because they came up to a determination that messed up the president's plans. Now, if I rely on that particular order from the High Court and the Court of Appeal, Justices Ngugi and Odunga can actually go ahead and sue the president right now, maybe in the Employment and Labor Relations Court, for the deficit in their remuneration compared to what they're earning now as High Court judges, compared to what they should be earning as Court of Appeal judges. And of course they would have a case, because that particular order allows them to do that. The president acted unconstitutionally, violating Article 166, because once he has received a recommendation from the Judicial Service Commission, he's supposed to ceremonially appoint all those judges to office. He didn't do that. But I'm saying, no, Justices Ngugi and Odunga cannot sue the president, even in such circumstances, because appointment of judges is a function of presidential office. And Article 143, Clause 2, prohibits, gives him immunity from being sued when he's performing a function of presidential office. Yes, he conducted himself unconstitutionally. Nevertheless, he has that defense in Article 143, Clause 2, and therefore the two justices have to wait until he's no longer in office. And that is where Article 143, Clause 3 comes in, limitation of time. I know it's been raised by the AG, it's been raised by the president's team, trying to misconstrue Article 143, Clause 2. No, it was there precisely to protect the rights of such persons, such as Ngugi and Odunga. If they decide once Uhuru is no longer in office that they want to sue him, they can, but they have to wait. They can't do it now. And that is why Article 143, Clause 3 is there. That same Article 143, Clause 3 can also apply to minor traffic offenses. For example, if you look at Section 50 of the Traffic Act, if somebody has committed a traffic offense, the person intending to prosecute you has to inform you within a particular defined period, 14 days or so, or send you a notice to your last postal address, and things like that. Now, we know every once in a while we see President Uhuru driving vehicles and everything else. He could commit a minor traffic offense just like anybody else. But because that particular criminal offense or traffic offense, as the case may be, does not fall under Article 143, Clause 4, one covered by an international treaty, you can't sue him. But since the Traffic Act puts very clear defined time periods, 14 days to do A, 14 days to do B, Article 143 protects the rights of the DPP to bring any prosecution against the president if he was involved in such a minor traffic offense, as the case may be. So Article 143, Clause 3 is not superfluous as suggested by the AG. The president does not have absolute immunity. He has limited immunity with respect to civil proceedings. Also, we need to get some clarification here. Article 143, Clause 3, sorry, Article 143, Clause 2 gives him immunity against civil proceedings being instituted against him. It doesn't talk about immunity against constitutional proceedings. It doesn't talk about immunity against electoral proceedings. After all, we have presidential election petitions. The president is sued. He was sued by Raila Odinga in the last presidential election petition. And that was valid and it was admitted before the court and the matter was dealt with. In other words, we are only talking about civil matters. Constitutional matters can be brought against the president. Electoral matters can be brought against the president in his own name. So when we hear the president's team trying to argue for blanket, absolute immunity on grounds outside the Constitution, you must not allow yourself to be misled on that particular path they're trying to lead us. In fact, they're calling upon the case, the Bellevue development case. It was decided, well, at least the lead judgment in the Court of Appeal was by Patrick Kiage. I've read through the case, and I believe that was a simple case of judicial overreach. Judges could be accused of basically protecting themselves and using their position, their office, to protect themselves as opposed to stick to the letter and spirit of the Constitution. If we, the people, in the exercise of our sovereignty, says you can't sue a judge except if they act unlawfully or not in good faith, we knew exactly what we're talking about. We cannot have a judge come and say, no, judges are superhuman. They're super righteous. I mean, you can't have a judge doing anything unlawfully or out of good faith. So therefore, I'm going to ignore those particular phrases, those qualifications. Unlawful, without good faith, that's out of order. That judgment was wrong. And when it came to the Supreme Court should have shut it out, but it did not. And I think even the Supreme Court was wrong. But then, as I said at the very beginning, you are not bound by the decisions of anybody, not even your own decisions. Therefore, don't allow yourself to be bound by that wrong decision which you affirmed, which came from the High Court. The letter of the Constitution in terms of judicial immunity is exactly as we put it. If you act unlawfully, if you act without good faith, you can be sued. I know the lower courts wouldn't do anything different to what you've said because they're bound by your orders. But now we're calling upon you to do the right thing. Be faithful to the Constitution. The sovereignty we delegated to you was only in accordance with this Constitution, not beyond this Constitution, not by the exercise of judicial overreach or any other judicial games people play. No. Just like we're supposed to be faithful, you too are supposed to be faithful to that particular Constitution. And therefore, the Bellevue decision case is wrong. Depart from it and do the right thing. Because right now the president is saying, well, judges, you gave yourselves absolute judicial immunity. The Constitution did not, but you gave yourself absolute judicial immunity. Come on, do me a favor too. Give me, the president, also the same judicial absolute immunity that you gave yourselves. That is basically what the president's team is asking over here. We cannot have that. No. Who is boss in this country, I asked earlier on. Is it Martha Koome? Is it Uhuru Kenyatta? Is it Devin D? Or is it us, the people? Who is boss? If we, the people, are boss, then our word should rule and prevail. And if we put qualifiers in judicial immunity, like unlawful, not in good faith, we mean exactly what we say when you put those particular phrases in the Constitution. They're not to be ignored by judges. You're supposed to act faithfully in upholding that Constitution. That is the delegated authority we gave you, not to act beyond the authority we gave you. So Bellevue decision is wrong. Uhuru Kenyatta as president cannot rely on that in an effort to get himself absolute immunity. He does not have absolute immunity. Section 3 of the Supreme Court Act talks about this court using history in an effort to get to the text and context of matters and all that. Section 14 of the retired Constitution was dealing with presidential immunity. You can compare that with Article 143 of the current Constitution, and you'll find that on the criminal side, we reduced the immunity of the president because we inserted Article 143, Clause 4, whereby we allowed him to be sued in criminal matters if the matter touches on an international treaty which allows him to be proceeded against. So we reduced his immunity. Very consciously we did that. When it comes to Article 143, Clause 2, dealing with civil proceedings, in the retired Constitution, you could not institute or continue any civil proceedings against the president. Then he had absolute immunity against civil proceedings. But under the current Constitution, you're only prohibited from instituting, which means if he had a pre-existing civil matter before he became president, that continues, which means again, we reduced his immunity in the current Constitution. So we, the people, reduced his immunity. The president is asking us, asking you as a court, basically to enhance it and give him absolute immunity. We cannot have immunity for impunity. No. We want a president who lawfully abides by this katiba of ours, lawfully abides by our national legislation. We cannot have him doing anything he feels like president, as asked by the second prayer of the president's team. The first prayer is faithful to Article 143, Clause 2. But the second prayer says he wants immunity for anything he does as president. If you grant him immunity for anything he does as president, then he'll be immune from any action such as what he did in this BBI case. He exercised state authority in pushing the BBI case, yet he had no authority under the Constitution to appoint the BBI steering committee to engage himself in constitutional change conduct. That is not allowable. He wants to be given more than we, the people, gave him. And you, as the Supreme Court, in being faithful to only in accordance with this Constitution, cannot. In fact, you have no power to enhance his immunity. I know they've given us very wonderful reasons: dignity, confidentiality of state matters, etc., etc., etc. Yes. But let us look at the record. How many cases in the last 11 or so years since the Katiba has been in place, 12 years almost, have been brought against the president on civil matters? On civil matters. Forget about electoral matters. Forget about constitutional matters. Civil matters. Frankly speaking, I'll be very hard-pressed to find any. Kenyans are not litigious against the office of the president. No. We respect that particular office. Even if you take my case in 2013, that was before Justice Lenaola, it was on a constitutional matter. It was not on a civil matter. I was not seeking any money from them. No. So let us be faithful to this constitution of ours. The president's team, they want to be granted immunity for impunity. We say no. We are a lawful, law-abiding nation. The rule of law is one of the principles of national governance that we have in Article 10. We have to uphold that. Everybody has to abide by the law in this country. Whether you're president, whether you're a judge, whether you're a private citizen, all of us have to abide by the law in this country. Under Article 27, which the president's team relied on, all of us are equal before the law, even if you're president. We do not have two tiers of citizenship, two tiers of persons. We are all equal before the law, and all of us must abide by this law. I will now touch on very briefly on the IEBC petition of appeal, essentially on the issue of the lower courts relying on a repealed law to come up with a determination that it didn't have quorum. I agree with the submissions of the IEBC on that particular point. Lawmaking is a preserve of Parliament. They make legislation. These were matters of legislation. When Parliament repealed the provision of requiring a quorum to be 5 people, and then subsequently the court ruled as unconstitutional the replaced law, the previous law had already been repealed. It was no longer in existence. Unless Parliament revives it, it remains repealed. And on that basis, we cannot use a repealed law as a basis of declaring IEBC to have been without quorum. IEBC actually acted with quorum as per the Constitution. It had 3 commissioners. And on that particular score, I will not fault the IEBC. If I want to fault anybody, I will fault the people who are responsible for setting up the committee responsible for putting in place the commissioners to be replaced, which is a parliamentary function. And maybe the president who's supposed to write and inform the parliament. In other words, if any blame should go anywhere, it should go to the appointing authorities, not to the victim commission. IEBC was here just a victim of circumstance, not of its own making. And the ones who were supposed to have remedied the situation did not remedy the situation. They were not brought before this court on that particular issue, so I think we can just leave the matter to rest there. I will touch on briefly to the other petition of appeal, Morara Omoke's one. I know there's been almost like a chorus saying that he's been asking the wrong question, whether we should be having multiple questions or singular questions in a referendum, whether he jumped the gun, he should have waited until we got to the stage of Article 257, Clause 10 and all that. But I think we need to reset something which was even mentioned by the AG's team and others who spoke in that particular regard, which is, in a referendum, we are voting on a bill. It is a bill that goes to Parliament. The parliamentarians vote on a bill. They don't vote on multiple questions, they vote on a bill. In a referendum, it is a bill that is put before the people, and they basically say yes or no to the bill. What was not said before this court was, what are the contents of this bill? That was a bit that was not mentioned by the AG, the President's team, the IEBC, and others who supported them like the Parliament. If you look at Article 255, 256, and 257, it is extremely clear and it is very consistent. In fact, there is no evidence of even a single inconsistency. A bill can only deal with a single subject matter, a single amendment. Therefore, yes, we vote on a bill, but that bill can only contain one subject matter. So let's say, for example, it was a bill touching on Article 255, Clause 1, Sub-Articles A to J. You cannot have a bill with all those 10 subject matters mentioned there. That is not in harmony with Chapter 16. You can only have one bill with one subject matter. If you want to address all those 10 subject matters, then you have to give the people 10 different bills and have 10 different bills circulating all over the country, each particular bill meeting the threshold of at least 1 million registered voters supporting it. That is what they should have mentioned. And if that is the case, which I believe is the case, then the issue raised by Morara Omoke's petition of appeal is actually addressed. We'll only be having one question in one bill in a particular referendum. Even if we had 10 issues come at once, we can have 10 different ballots, one ballot for each bill. Just like we have 6 different elections in a general election, a voter is given 6 different ballot papers and you vote for each different position. So in this particular case, we should be given 10 different ballot papers, a ballot paper for each bill, and we vote individually for each bill. That is basically the position in Articles 255, 256, and 257. And that is basically what this court should clarify, such that when parliamentarians within Parliament are debating on constitutional change matters, they restrict themselves to one issue in a constitutional amendment bill. And the same applies to anybody pursuing the popular initiative route. One issue for each constitutional amendment bill. That is the clear record in the amendment chapter of the Constitution. And that also addresses one of the defense mechanisms we have inbuilt in this Constitution against the hyper-amendment culture that we had from 1963 until we had this Constitution in 2010. I know some of us have tried to bring the basic structure doctrine as a defense mechanism, but that is not permitted by our Constitution. But what we put in place here to forestall the culture of hyper-amendability of this Constitution is that if you want to amend it, you can only bring one issue at a time. And therefore it will take a pretty long time. Knowing how long it takes to collect 1 million signatures, how long it takes to do all these things, it might take maybe 74 years if these people who are promoting the BBI bill wanted to have all the different issues in the BBI to be passed by this particular country. So it is an inbuilt defense mechanism we have in our Constitution for its defense. I am urging this particular court to uphold the inbuilt defense mechanisms and not to import illegal, unlawful, unallowable defense mechanisms as a basic structure doctrine in the defense of this Katiba of ours. So basically I'm going to wrap up, and whatever time that I don't use, I am going to very willingly and gladly donate all of that time to Morara Omoke, because other parties have donated the time to the AG and the IBC. I think let's give the other petition of appeal also some fair time. So any time that I don't use, I'm going to donate that to Morara Omoke and his team. But essentially, I began by asking the question, who is boss in Kenya? Is it Martha Koome, the President of the Supreme Court of Kenya? Is it Uhuru Kenyatta, the President of the Republic of Kenya? Is it David Ndii, the champion of the basic structure doctrine, as represented by President Nelson Harvey? Or is it us, the people? In this Constitution of ours, we the people are the sovereigns. We are boss. We have limited the exercise of our sovereignty to only in accordance with this Constitution, and so we must be faithful to this Constitution. Any constituted power, be it the executive, legislature, judiciary, independent commissions, must conduct their affairs to only in accordance with this Constitution, because that is the sovereign power that we've delegated to them. We have reserved to ourselves exercising our sovereign power in a manner different to this Constitution, but only when we change Article 1, Clause 1. For now, while Article 1, Clause 1 remains in our laws, we have not allowed ourselves and anybody we have delegated our sovereign power to do anything different from only in accordance with this Constitution. I think with those particular remarks, I rest my case, and I hope when you retire to your judgment, you do the right thing. Thank you.
Thank you for